Hello, everyone. Thank you so much for joining us for our H1B Cap Season Seminar. My name is Jillian Poirot, and this is Keshav Rajsadai. Keshav has been practicing immigration law for over 20 years and has successfully filed over 75,000 H1B registrations.
H1B visas.
H1B visas.
Yeah, registration is started in 2020. That's why.
Okay, there we go. We're glad that you're here, and we hope that through this webinar you'll learn and maybe begin to understand and learn how to implement some of the best practices for all aspects of the H1B process, ranging from registration to selection and filing, and ultimately the most coveted thing that we all want, which is the approval. I'm going to provide a brief roadmap for our discussion today. So first, we're going to talk about the steps to applying for the H1B visa lottery, the expected timeline, as well as any tips for increasing your chances of being selected. Then we'll move on to discussing who's qualified to sponsor an H1B visa and the intended employer-employee relationship. The third item on the list for today will be a brief discussion of the role that the employer plays in formulating the right job title and making sure that the duties listed match with the employee's qualifications and background. And then lastly, we're going to finish up with telling you guys about the possible maintenance of status issues that could arise, as well as any issues that could occur when adjusting from CPT, OPT, STEM OPT to H1B.
Excellent. Thank you.
You're welcome. So I'm going to give a timeline of the H1B registration process. So for this CAP season, starting February 21st, you can create your account on USCIS. So the steps for that, first you'll go to myaccount.uscis.gov. You'll click on create an account, and then you'll select the account type as I am an H1B registrant. And then on March 1st, a date that you should all be very mindful of, is when registration opens. And you can register by following the steps that I'm about to tell you. So the first will be to log into your My USCIS account. You'll provide the email ID used to create your company's My USCIS account to your attorney. And then once the registration is started, your attorney will notify you and provide you with something called the representative passcode. You'll then enter the passcode and review the beneficiary or petitioner's information and sign digitally to complete the registration process. So a few notes here, all of the information will be entered by your attorney. The only thing that you will need to do is to review and sign. Also, the passcode will not work correctly if the email ID used for your company's My USCIS account does not match the one entered by your attorney. So please be mindful and make sure that you are giving your attorney the correct email ID. And also just of note, the number of H1B petitions submitted during the registration process continues to rise. For example, in 2021, there were 275,000 applications. In 2022, there were 308,000, and then last year there were 483,927 applications. So that just gives you a ballpark idea of maybe how selective the process is and how important it is to apply early and make sure that you have all of your ducks in a row so that things can go seamlessly. And then, a point that we'll hit on several times is just that you can only register once per year. So again, just making sure that everything flows cohesively is one of the most important things that you can do. So again, the registration will open on March 1st and it will close on March 17th of this year. And
the February 21st is going to be the
time when you can
register, create an account.
Right. So for each H1B Cap registration entry, USCIS requires several things. The first one would be the employer's name, employer identification number, and address. The second,
can you stop one second?
Yeah.
So when you are, registering, and later on, if you get selected and you're filing an H1B, you got to be mindful when during the registration, you're using the proper LLC or company name Inc. or tax ID. We have a lot of different situations because the client provided, they had 2-3 companies with the same name, and instead of giving Inc., they gave a LLC information. And by the time filing of the H1B and the LCA verification time, they didn't have the paperwork for the other company. So you want to be careful using the appropriate information of that particular company and the tax ID. Please continue.
Yes. So then the second component that is required for the registration is the employer representative's contact information. The third is the beneficiary's full name, date of birth, country of citizenship, gender, as well as passport number. The fourth component is just stating whether the beneficiary has obtained a master's degree from a U.S. institution of higher education, and that's important for a very specific reason that we will highlight on later. And then the fifth is the employer's attorney's information. And so again, I'll just keep repeating throughout this. The registration will open on March 1st, will close on March 17th. The next important date will be March 31st, and this is the date on which the selected employers and beneficiaries should be given the notices. The notices will go to the employers, and at that point, once you've received the notice, you will be given 90 days to submit your completed H1B Cap petition. And then after that, so again, that'll be kind of April to May or June. Right. April to June is when you can file your completed. And then if all of the H1B like spots have not been given out at that point, like if enough people have been selected and haven't completely filed their applications, then they will do something called the second chance lottery. This will occur most likely in July, and then that'll be
July and September maybe.
Yeah, September would be the third chance. Right. So in the second and third chance lotteries, that's USCIS trying to allocate any unused H1B visa numbers. So with that, I'm going to start asking Keshav some questions.
Sure.
Okay. Keshav, could you please tell us what are the most critical things companies should consider when filing applications for the H1B visa lottery?
Thank you, Jillian.
You're welcome.
You've presented very good information for all of our clients and friends, and we're looking forward to working with you, and nice to be with you today. So H1B lottery, this process of registration per se started in 2020. So 2020 onwards, it's been 3-4 years of exercise. Things are still in progress for employers, attorneys, as well as the USCIS. And hopefully, within a couple of years, they will make it digital uploading of all the documentation, so we don't have to mail the paperwork out. So that is the one expectation we're making with the Homeland Security and the USCIS. The LA is working on it, as well as the USCIS, all of the court system, right? Mm-hmm. You have all e-filing. There is no document filing of hard copy. Mm-hmm. So we expect for this rule to come to the USCIS within the near future, even though it's not yet there yet. So what I have seen during these 3-4 years of H1B registration is primarily, I'm going to kind of read it here. Make sure you have the correct name of the company, as I stated earlier. Company name, tax ID, and the address of the company. You want to make sure there should not be any discrepancy after you get into the lottery. You get selected, but at the time of filing LCA, you have a problem in filing the case, which is going to deny the case. Double verify the employee name, date of birth, and the passport number. And also make sure those credentials, name, date of birth, and the other basic information of the employee also match with their degree, diploma, and the experience letters. If there is a mismatch, you have a problem in presenting the case. You got selected, but when you file the H1B, you still have an obligation to prove the beneficiary is qualified, or his credentials are in a wrong name. It's going to create a problem. So make sure you're matching these elements before you register the guy. Now, the third is going to be, as Jillian said before, regular versus the master's cap. So regular cases just requires a person either bachelor's degree, which is a high school plus 4 years of college degree, with the graduation, obviously, in the related field. If it's a computer science related degree, it would be better for the software engineers, program analysts, or DBA type of jobs, right? Now, if India degrees have 3-year degree. Now, person might have 3 years of additional experience, which can be combined with the credential evaluation company can use expert opinion letter or a combo eval and produce a 4-year degree. So those degrees can work for a regular cap, not for master's cap. Now, the problem is with the master's cap, right? One, does the guy have a master's degree at the time of filing H1B? Number two, if she or he has the master's degree, is the master's degree originated from the accredited university or college? Number three, is that degree accredited university is public university or is a private non-profit university? So you have accredited university, public university, or private non-profit university. For-profit university, on the other hand, is not qualified for the master's cap. Those cases will be rejected. If you mark master's now, and when you submit let's say person gets selected, you file the H1B visa petition, at that point of time, USCIS will reject the petition. So you don't want to do all this exercise. So you need to go to the Department of Education website and verify this is a accredited university, number one. Number two, you got to do further research to find out about that university or college. It is a non-profit 501c3. IRS has designated as a 501c3 entity, non-profit college or university. Then and only then you will be able to secure the master's cap, because a lot of people have a benefit, right? More than 16-70% chances are higher if you have a US advanced degree, which is a master's degree or PhD.
Should we tell them number-wise how many visas or H1Bs are specifically allotted for the master's cap?
Yeah, I mean, we're going to go. So now what's going to happen is, as Jillian said, the master's cap people, master's degree holders or PhD advanced degree holders have a double dipping. So when the USCIS runs the 65,000 visa lottery, they will put, let's see, this year they're going to apply 550,000 people are going to apply. All 550,000 people, including the US master's degree holders, are put into one bucket, and then they run the lottery. So whoever gets the US advanced degree and the foreign degree holders, everybody get the whatever, that 65,000 number came out. 65,000 number is not really true, because almost 6,800 visas are allocated from that file to Chile and Singapore, H1B1. So whatever numbers are left. So those people, now whoever did not make it into that lottery of 65,000 lottery, masters, US masters, and the foreign degree holders, they were all put in one pot. Now whoever did not get in, US advanced degree holders are again selected and put it into that 25,000 lottery. Or they will just get 20. If there are less than 20,000, everybody gets it. If there are more than, most of the time, more than 20,000. So they will go into a second lottery. So you have double dipping going on, double chances, right? So that chances in the past has increased about 15 to 16%. You have more chances of getting in H1B visa lottery than the regular cap people. So make sure you have the master's degree from an accredited university, either which is public or non-profit private university. So those institutions are qualified to file or to claim as a master's degree under the master's degree cap, right? So now the other situation comes in is, can the same company file do not file multiple H1Bs from the same company or affiliated companies. So that's the problem. But you have another question for me into the file looks like, right?
Well, that was going to be a question, was going to be just, can you file multiple H1B registrations from the same or affiliate company?
Okay.
It sounds like
okay.
the answer is
So the answer is no.
no.
The answer is no. Now, same company, everybody knows. You don't want to file double cases. But some companies have ended up filing from other companies which are affiliated to this person. Now, what is affiliation, right?
Mm-hmm.
The H1B rules, they haven't defined what is affiliation into the USCIS website or the HCFR. There is no affiliation in the context of the H1B filing. They haven't defined. Mm-hmm. Now, we can look into what is the definition of the affiliation within the USCIS framework in the L1 visa context. Under the L1 visa, affiliation or affiliated company means a company owned by same or similar individual. So if I own company A, mm-hmm. and then I also have a ownership interest in company B, even though it's a completely separate company. It has a different tax ID, it has a different incorporation, everything is separate. But in the H1B context, what the government is trying to tell us is if I have an interest in a company B, then, or this company has an interest on company B, ownership interest, mm-hmm. then both the companies cannot file H1B for the same person. That is the affiliation concept, right? Mm-hmm. Multiple no, affiliation no. Now, another situation is there, a lot of companies try to kind of gang up with each other in a positive way. So the same guy is being filed by 3-4 different companies, but the end client side is the same. So in a situation like that, also the USCIS has written in the attestation that would be considered a material misrepresentation, or you didn't have a good faith and you're trying to scheme the system, and they will deny this type of H1B visas also. So, you know what, when I'm reading this question, right, you already gave the number. Mm-hmm. So I will just add in this, then we can go into the other areas. So, I'm just going to kind of rephrase the question in one package. Consequences of not filing H1B after selection, or filing H1B registration without an actual job offer. So company really did not have a job offer for this guy, but they just took a chance and just filed one lottery. It's just going to cost a $10. We're just going to register it. Or filing multiple applications through a same company or affiliate company we just discussed, or coordinating with multiple companies to file a H1B for the same individual, which also we discussed. So in this context, we need to go back to the USCIS website and their registration protocol and see what does it say. Let me read it to you. When submitting the electronic registration, the following attestation is required. I further certify this registration reflects a legitimate job offer, and that I or the organization on whose behalf this registration is being submitted have not worked with or agreed to work with another registrant, petitioner, agent, or another company or individual or entity to submit a registration to unfairly increase chances of selection for the beneficiary or beneficiaries in the submission. I had already summarized, right? So I'm just reading from the attestation page. So they already said in all of this context, what's going to happen? Let's see, somebody colluded in filing the H1B through multiple employers, or there was affiliation being filed, or there was no actual job available for this foreign worker. or the H1B applicant. What's going to happen? What are the consequences of that, right? That's what we're trying to discuss. Now, the USCIS further states on its website that if USCIS finds that this attestation, which I just read it, was not true and correct. For example, that company worked with another entity to submit multiple registrants for the same beneficiary to unfairly increase chances of registration, right? Chances of selection for the beneficiary. USCIS will find that registration to not be properly submitted. It will deactivate. Properly submitted. Since the registration was not properly submitted, the prospective petitioner would not be eligible to file a H1B petition. So they're not allowing you to submit the petition. Based on that registration, in accordance with the regulatory language, which was also incorporated in HCFR, USCIS may deny or revoke a petition based on the registration that contained a false attestation and was therefore not properly submitted. Therefore, USCIS may also refer the individual or the company who submitted a false attestation to appropriate federal law enforcement agencies. It could be FBI, FDNS, any type of federal agencies for investigation and further action as appropriate. So you got to be mindful when you are filing these cases. You want to be legit. You just don't want to have a headache of following by FBI or FDNS. It's not worth it. Now, I wanted to find out, is there some kind of a mechanism? Let's see, you genuinely filed H1B registration. Filed, you got selected. In a situation like this, it was a genuine filing, right? But your employee changed his mind. Maybe he filed from 2-3 different employers. He decided to go to another employer. Did not want to come to you. So what is the mechanism there to notify the Homeland Security? Or how do you protect yourself if in case there is an investigation by the feds to see, you can explain to them, look, it was a bona fide submission of the lottery. However, the guy did not come to join. But what documents you're going to back up and keep it in the file, or you send a letter to the USCIS? I wanted to find that answer to that question. This is what I came to know, okay? So USCIS for this, H1B lottery registration, there is a FAQs. FAQ 25. How should a registrant with a selected registration notify USCIS if they do not intend to file a petition? Now the answer to the question 25 is as follows. Since an H1B petition will be filed, we will have no paper file that we can use to match the notification with the registration because H1B was never filed. So even if you write a letter and send it to them, they cannot put any file. There is nothing to justify. We suggest that the employer keep documentation of the reason for not filing so that the employer would be able to show us the documentation if we have questions or if there is an investigation. So you're going to put a public access file type of documents because just keep a file of that guy, wherever you had filed the lottery, and then you keep the justification documentation. Maybe the employee send an email to you, I'm no longer coming, or do not file my H1B, I'm not interested in joining your company, whatever the situation is. So you print and put it in the record so you can show it later, you see. So that is the basic H1B registration to do or not to do or what to do. Explanation.
Awesome. Okay. I guess now maybe can you tell me a little bit about who's qualified to sponsor an H1B visa and maybe the intended employer-employee relationship?
Sure. H1B, is a visa for to employ foreign workers who hold minimum of bachelor's degree in a related field. Under the quote-unquote USCIS language, employer must have a specialty occupation. available at the time of filing H1B for a qualified worker. Now, who is the employer? Who can be the employer, right? Employer could be a corporation. Employer could be an individual also. So long as he or she or that entity has work, specialty work to employ a foreign worker and is ready, able, and willing to pay the prevailing wage set forth by the labor condition application.
What areas qualify as specialty occupation?
The specialty occupation is a very simple analysis. What the USCIS is looking, right? When you are filing, you file a H1B. This is just a lottery right now. Lottery, you get selected, you got the selection notice, you put it in, and the service center address is there. You file the H1B, and you prepare the I-129, you supplement, data collection page, LCA, everything signed and done, degree, diploma, transcript, passport, visa I-94, I-20, OPT, all the required documentation you attach, you file the case. Once the USCIS gets the file, they're looking into three elements. One would be whether this company is bona fide, or it's not some parking lot, there is not even building. So they do wide database search to see the company is a bona fide entity. If they believe company is bona fide, now they want to know if this company has real work. So if a accounting firm is filing for a lawyer, they're going to have doubts, right? Or a law firm is filing for accountant, they might not have doubts because accountant is needed to count the money. So they're going to look at this, different relationship with the jobs, or a consulting company. File on LCA has an end client site address, but you don't have any end client letter, contract PO, or vendor letter. In a context like this, obviously the RFP is going to come out. So they're trying to verify whether there is availability of the specialty occupation. That means that professional employee requires job to do, whether in-house or at the client side. So they're trying to verify whether the job exists. If job doesn't exist, the H1B doesn't exist. You see, very simple. So that is one element. Now the second element would be whether your employee is qualified to perform those specialty occupation job duties. Does he have a relevant degree to that field? Or if the degree is lacking, is he able to combine the work experience with the degree and produce a US or foreign equivalent degree into that platform, which makes him eligible or qualified to perform the offered job duties? So these are the basic tenets, basic elements of the H1B. So when you're looking for H1B, you got to make sure the job is matching to the qualification, and company is ready, able, and willing to prove either it has a job in-house or has a job offsite at a client site. A client side documentation would be proven through the client side contracts, PO, end client letter, vendor letter. Those type of documentation are critical at the time of filing H1B. Thank you.
And maybe a bit about the employer-employee relationship, right to control.
Yeah. So the employer right to control came. It was right after this. Recession. U.S. was going through very hard time. TARP funding came in back in 2009, and then all these new field memo came in. So new field memo was the initiation of this. Before then, there was nothing. If I recall my history, when we started the filing H1B, there were only 3 pages. 2 pages I-129, 1 page LCA. We had to fax the LCA, comes back, and then we just write a little bit here and there. No end client letter needed, nothing. H1B got approved. It's straightforward. We just attach degree, diploma, transcript, and done. It was very easy and simple, way million years ago, right? No longer is the case now. So now, if you are employing in-house, obviously you got to prove through your tax return, your maybe lease, bank statement, and then nature of the business, explaining why you have a job or how you were able to convince the USCIS adjudicating officer, this company does have this job at this site in-house. Or you're building a software, you got to show them, look, I'm building so-and-so software, I need 5 engineers, software engineers. So whatever context it is, you got to explain to them in a layman's term, not into high technical. If officer doesn't understand, he will issue RFP, you respond to the RFP, officer still doesn't understand, he will deny the H1B petition. Now you need to file a motion, appeal, or federal court litigation. So there is no point in all of this drama, where you can simplify in explaining the situation to the officer in the beginning, how you can prove in existence of a specialty occupation, right? Now employer-employee relationship is for the third party, and the control is for the third party placement. You're sending a guy, let's see, a company ABC send the software engineer to Apple. Now immigration would like to know, is he going there as an employee of Apple or going there as a representative or independent contractor of the H1B sponsoring company? So those variables get confusing to the USCIS officers because they're just going by the paperwork. So we need to be able to overcome these issues by getting a letter from the Apple. I'm just giving an example, right? The Apple is going to say, look, ABC company has placed this so-and-so, Bob Smith, to this job site. He will perform the following job duties. He will be working as a software engineer responsible for researching, designing, developing, testing, coding applications. And in order to perform the foregoing job duties, he needs a minimum bachelor's degree in computer science. While he's working at Apple location, ABC company shall remain responsible for paying, hiring, managing, controlling, and employing this individual in its entirety. Having said that, when you look at the contract between the ABC company and the Apple, the contract says it is an independent contract agreement. When you submit that letter with the independent contract agreement between Apple and ABC company, now officer understands the actual employer in this context, who has employer-employee relationship and who has actual control over this employee, is not Apple, but the ABC company which filed the H1B. So those are the things we want to keep in mind. So it's easier to convince the officer we have a bona fide job offer for this H1B applicant, so the H1B can get approved and everybody can move forward. Thank you.
Thank you. Now I'd like to know maybe some possible maintenance of status issues that could arise.
Well, the foreign workers who haven't come here, so you don't have to worry about maintenance of status issues because they are free and clean, they're overseas, they might have a problem, they might have applied visa before and got denied, which you don't know. You might come to know at some point of time down the road when he applies for the visa, DS-160 completes. But those information you might not know. You might know sometime. But folks who are in the US, who could be on F1, OPT, STEM OPT, CPT, F2, L2, E2, O visas. So there's tons of other J1 visas. So those non-immigrant who are transferring, who are changing their status, or could be even B1, B2, all these alphabets of these non-immigrant visas, you're moving from non-immigrant one category of visa to the H1B, you have filed change of status. Whenever you are filing a change of status within the United States, USCIS would like to verify the person or the beneficiary or the applicant has been maintaining a valid non-immigrant status from the date he entered into the US until the day H1B takes effect. And most of the time, change of status takes effect, even though you're filing in April or May or June for that matter. H1B starts in October 1st. So you want to make sure you want to calculate those timelines before you spend so much money in filing the H1B. Maybe person is out of status. So you need to ask your attorney or by yourself, do the due diligence on those files to see whether he can hold the water or whether he can verify or provide the sufficient documentation to overcome any problem during the RFP or questioning when there is a questioning by the USCIS related to the maintenance of status. Of every situation is different, right? L2 person coming, H4 person coming, also have to prove their spouse were maintaining status on L1 and H1. Not only the person maintaining status on L2, which is most of the time you don't have to do anything other than work illegally, right? Then you are out of status. You have scenarios where maybe spouse is not maintaining the status. So you want to do those due diligence at the time of getting paperwork before filing the H1B. And similarly, F1 people, maybe they are on a already, lapse status. They don't have a status. Even though they have an OPT, maybe they didn't work. OPT requires unemployment for 3 months. They can have unemployed 3 months, STEM OPT, additional 2 months, about 5 months, right? So you want to also talk about with these people. And the CPT, maybe he worked, maybe there is no endorsement in the I-20. I just got a case from one of the clients. Everybody, it's a very big company where the guy went to work. He worked there on CPT. Everybody thought, oh, he's on CPT. Nobody did the CPT agreement. There was no cooperative agreement. There was no I-20 endorsement, nothing whatsoever. Now, when he went for the renewal, now the school terminated his F1. He said, oh, you worked illegally. So there's just so many gamuts there. So you want to be mindful of all the visa category, whatever category they are moving from to H1B, make sure all the T's are crossed, I's are dotted, and you have the appropriate pay stub, 3 pay stub, and just don't look at the pay stub. Maybe he didn't file amended petition, even the H1B transfer guy, or the YTD is very low. The salary is too low. So there's so many issues there. We need to overcome those problems and analyze in a case-by-case basis and find the appropriate solution and then move forward. Thank you.
Thank you. So just a clarification question. If I'm an employer and I have an intended beneficiary that has been out of status for any amount of time, even if it's just like a month, then it would not be beneficial to go through with the H1B registration because they likely won't be granted it, or like?
That's a very good question. That's a very good question. See, H1B transfer people, you have 60 days. When you get off the previous employer, from the last day of your pay stub, you have 60 days, right? For all of the people, you might not have that grace period. So you need to make sure you have that, as Jillian said, look into their background, whether they are maintaining their status. Even if it's 2 days, if you, let's say you I-94 expired, right? I mean, we might be able to file on the non-pro-tunc basis in justifying in a different language and you still get the job done, but chances are very slim. It might not happen. So we gotta be mindful of that. Whether the person is maintaining a valid non-immigrant status before you submit that H1B change of status application. Thank you.
Thank you. Well, I mean.
So we covered most of the areas?
Yeah.
Thank you, Jillian.
Thank you.
I mean, I would like to encourage you to, move on to the registration as soon as possible. Do the vetting of the applicant, their name, date of birth, passport, degree, diploma, transcript, and whether they are qualified for, where do you want to spend even $10 or file a registration if the ultimate H1B will be denied. So do that analysis beforehand. That's what I would recommend. And then let's complete the registration and we move forward for filing the H1B in the month of April, May, June. We have 3 months after the selection is completed. And if you have any questions, email to us, help@greencardmaker.com. Our website is greencardmaker.com. Help@greencardmaker.com will answer your question. You can even reach out to me, Keshab, K-E-S-H-A-B, Keshab@greencardmaker.com, and Jillian@greencardmaker.com. We'll be more than happy to answer your questions. Looking forward to talking to you folks in the near future.